Well, it's important to appreciate that two matters came up today that involve our party. The first one was the matter that we filed, and the second one was the matter that was filed against us. In respect of the matter that we filed, we took advice and guidance from our team of lawyers that in view of other matters that are pending in many other courts, that there may not be need for us to continue with that matter, especially in view of the application for recusal, which we filed before the court in respect of that matter, and which application the judge had said she will take along with all other applications. Now, we accepted the advice of our counsel and then asked them to come within the provisions of Order 50, Rule 2 of the Federal High Court Civil Procedural Rules to withdraw without the leave of the court. Now, in ruling on that application, instead of striking out the matter, the court now dismissed our matter. So we are going to take further advice from our team of lawyers on what options are available to us, including and not limited to the right to appeal against that ruling. In respect of the second matter, at interlocutory stage, the judge had made orders which for us are so overbearing as to affect even the main issues for determination in the matter. And we've instructed our lawyers to appeal against those orders to the Court of Appeal, which appeal has been done and then entered in the Court of Appeal, and the records have been transmitted, briefs have been filed, and an application for stay of proceedings in accordance with the rules of the Court of Appeal have also been filed in that court. And all these facts have been brought to the attention of the learned trial judge in an affidavit of facts. And so our lawyers applied that in deference to the Court of Appeal, that this court should now stay proceedings until either the hearing of the application for stay or the appeal itself are heard and determined one way or another. Now, even though the judge had agreed that in the circumstances and by reference to the position of the law, that she has no option but to do that. But in her own wisdom, she said that we should come back on the 20th for mention. Probably 20th of February. Probably by that time, the appeal or the application for stay of proceeding will have been heard one way or another. So we will come back on the 20th and then report to the court if our application or appeal has been heard. But we are confident that on the state of the law, that our appeal is recondite. We have raised very strong and substantial issues which will be determined by the Court of Appeal, and we are hopeful that we'll be successful. But the fact remains that in a situation where for any reason, and I've stated this before, for any reason a litigant has genuine apprehension that that litigant may not get justice and had applied for recusal, that the most reasonable thing to do by that judex is to recuse herself or himself from hearing that matter. Because when an application for recusal is filed, it brings to fore one difference, one area where a distinction is made between the judex and the court. In all other matters, the judge will be taken for the court and the court will be taken for the judge. But when an application for recusal is filed, then you now draw a distinction between the judge and the court. Because you are not saying the court does not have jurisdiction, but you are saying that for reasons that have generated fears in you, the judge, even though the court itself has jurisdiction, but the judge should recuse himself or herself from that case. So it's something that is really substantial and foundational. But we pray that at least we keep on learning. That is what lawyers say. We keep on learning and we'll be guided by the judgments of the Court of Appeal. Thank you very much.
You see, it is most unfortunate that the PDP that is supposed to get its house in order in preparations for the 2027 general elections. You could see clearly from the frivolous applications seeking for adjournments here and there from the opposite side. It is very clear from all these applications that you know who are the genuine PDP members who really wants to take this party to where it belongs. How can you, in all purpose and intents, a suit which seeks to address all pending issues, all the issues that have stagnated the party, they are coming up with frivolous applications to the Court of Appeal here and there. So it is most unfortunate, quite all right. My Lord has listened to them and has adjourned till February 20th, or pending when the appeal is determined. This suit is actually a suit which, like I said earlier on, will help members of the party to know who are really the genuine and true leaders of the party. But they are afraid. If they have facts that will support them, if they have facts that they feel has legitimized their positions as the so-called National Working Committee, why are they afraid of taking the motions before the court? So it is most unfortunate that we thought this matter will be hard to get dispensed, and then we wait for final judgment. But you could see, withdrawing a motion for stay that was earlier before the Federal High Court, they have now moved to the Court of Appeal to file another motion for stay of proceedings.
Sorry, one issue they raise is that they say they don't have confidence in the judge.
Well, this is most unfortunate. How do you just simply sit and say you do not have confidence in the judge? Assuming you don't even have, why not wait when judgment is delivered, you appeal? What are you afraid of? Facts don't lie. Facts don't lie. Present your facts, argue your case, and that's all. If there's anything you are not comfortable, that is why we have the Court of Appeal and the Supreme Court. So you cannot come out and say you do not believe in the impartiality of Judge 1, Judge 2, Judge 3. Do you want to bring your own personal judge to adjudicate over this matter? It is not done so. But this is not even what they put before the court as the basis for their appeal. The basis for the appeal is simply stay proceedings. Why do you have to stay proceedings? If you have your facts, come and argue it. As far as we are concerned, the world, even with this application for adjournment, the world knows who are the genuine leaders of the PDP. The basis of all of this is there was no convention. And if they felt they had conducted a legitimate convention, why not come and tell the court that, yeah, our convention was valid, we were elected legally? Unfortunately, they know. So since the matter has been adjourned, we await to hear, or we pray for God to spare our lives to see the next adjourned date. But it is most unfortunate. It is most unfortunate.